So we move on to the second session of today, which is scheduled to be delivered by Dr. Eva Micheler. It's a proud privilege to be presenting her profile across to all of you. Dr. Eva Micheler is an associate professor at the law department at the London School of Economics. She's also a member of the management committee of Systemic Risk Center at the London School of Economics. Dr. Micheler studied law at the University of Vienna and at the University of Oxford before joining the LSE Law Department in 2001. She is also a member of the expert group on technical aspects of corporate governance and is advising the European Commission and a member of the Investor Protection and Intermediary Standing Committee of the European Securities Markets Authority. She's written widely on corporate and comparative law. Her most recent book, which is published by Oxford University Press, is titled Company Law, a Real Entity Theory. Today, she's going to be talking to us about how law can address problems with corporate culture. A very interesting topic. And the title of her topic is Role of Culture in Corporate Law. Over to Dr. Micheler.
Yes, so thank you very, very much for the invitation. It's a real privilege to be here with you. And let me kick off by saying that the seeds for this event were sown about a year ago when I was looking for someone for an SRC conference to write a report or help write a report and take notes at the event. And that was, of course, Anna Mika, who is working for Anata Barua's team. And then a year later, what we are having is a partnership between the SRC and SEBI and another conference where I'm delighted to be able to speak. And I think it goes to show how very small events sometimes have wonderful, large consequences. And it also is so wonderful to see that our students take so much initiative. And that's one of the things I really enjoy about my job, that I'm working with energetic, young, bright things who conquer the world and take opportunities when they see them. So that's a wonderful thing. And I just wanted to kick off my presentation with that. Now, my topic then, and let me share my screen, is corporate culture in corporate law. And I'm going to go here and start my slideshow. So, and I've slightly here extended this because in putting together the slides, I realized I should probably connect this strongly to financial regulation, which isn't very difficult. But it is a topic that is generally affecting corporations, affecting corporate law, and affecting regulation. So let me start out by giving you a definition of corporate culture. Many people have tried to define what culture is and what corporate culture is. And I'm using the one from Turnstall of 1983. He says, a general constellation of beliefs, mores, value systems, behavioral norms, and ways of doing business that are unique to each corporation. So we're seeing things like beliefs that people share, values that they have, ways they behave, and these are unique to the corporation. The lawyer's perspective on this is that corporate culture is something that means when something goes wrong, it may not always be possible to identify individual wrongdoing. And it is possible for wrongdoing to be caused and facilitated by toxic corporate culture. So we're dealing with a phenomenon that is between people and cannot be distilled into individual wrongdoing, but has effect on individual wrongdoing. And I think the best place to start is with 3 examples of how corporate culture affects things that can go wrong. So I'm showing you here an image of the space shuttle disaster that happened in 1986, so some time ago. And Diane Vaughan has created or has researched what went on in the lead up to the disaster. And her conclusions is that NASA at the time, and I'm reading this out, was characterized by a culture of high risk taking, which normalized deviance from evidence that something was wrong. So the disaster then was caused by the banality of organizational life. And it was a culture of high risk taking in an environment that had a lot of time pressure associated with it. And so many people overlooked and didn't react on a knowledge that there was a problem, which may or may not cause an accident. And in this particular instance, it did. And here's another example, this time from financial services. So this is Tom Hayes. He was convicted in 2015. He worked for UBS and Citigroup, and he was involved in rigging LIBOR, so the London Interbank lending rate. And here again, there was an individual who did wrong and who was convicted of wrongdoing, but his actions were facilitated and encouraged by a corporate culture that made it easy for him to be a wrongdoer. So what I'm not saying is, I'm saying definitely he's to blame, but I do note that he was a mid-ranking individual who came to this as a perfectly honest person, but then became embroiled in manipulating the lending rate, and that was facilitated by the environment he worked in. And I'm sort of working on the hypothesis, if that environment hadn't been the way it was, he probably wouldn't have been a wrongdoer. So we're dealing not with people who are criminals to begin with, we're dealing with people who become embroiled in criminality because of a cultural environment that they work in. Another example is Kweku Aduboli. He worked for UBS, and this was after the financial crisis, and he did unauthorized trades to an eye-watering extent. And that was, of course, also something that led to a conviction. But he too was a mid-ranking individual. And again, we see a situation where there was a wrongdoing by a person, but there was a cultural background which encouraged, facilitated, and normalized wrongdoing. So what then are the factors of toxic corporate culture? Oh, hang on, this is some more evidence here. So these are two papers. The first one is a paper where Earhart and Fiorito examined how they examined 25 corporate scandals, and their conclusion was that very rarely there was even an individual fraudster or a rogue trader, as we had in the previous two examples. The majority of the cases that led to corporate scandals were organizational failures. So there were facts that most people, including management, knew, and that led to serious problems arising. But you couldn't pin down anyone who had done anything wrong. And so the wrongdoing was in the culture between the people. And there's a very recent Bank of England paper going back to the sort of more regulatory space. So that was a paper published last March, less than a year ago. And the authors conclude that it's an empirical paper, that they have robust evidence that poor culture leads to substantially higher risk, demonstrating the importance of bank culture for prudential outcomes. So I believe I've now kind of identified what I mean by culture and how culture affects law and regulation. Now, what are the factors then that contribute to individual wrongdoing that may not have happened in a different cultural environment. So I'm kind of zooming in at the heart of the problem. My hypothesis is that wrongdoing may not happen if the cultural environment had been different. So what are the contributing factors to individual wrongdoing? Well, in what way does corporate culture manifest itself? Two decisions that are made by companies are remuneration and promotion decisions. And those are done according to some criteria, but there are also informal criteria which inform these decisions. And these decisions have a significant steering effect on how people behave in an organizational environment. So what happened in the two banking scandals involving Tom Hayes and also Quaker Abadoli there was sort of extreme pressure to minimize cost. There was extreme pressure to maximize return. There was a culture of overworking, which led to a situation where it was impossible to have relationships outside work. So there was no other framework which normally gives people a moral compass, which normally allows people to reflect on what they're doing, because people's lives was completely dominated by this work environment. And in that environment, unethical and unlawful behavior was normalized. So there's an FT article in which Quaker Abadoli describes when he joined, his first job was helping some clients to avoid tax in a certain jurisdiction. And that is sort of, his job became one of organizing systematically the breach of legal rules by clients. And that's sort of a cultural introduction that gradually draws you in and then normalizes that your job is also involved in unethical and unlawful behavior. So individuals then lose their moral compass. And another failure that comes out of these scandals is sometimes governance is too dispersed. So there was trades in the UK, there was management in the US and risk management in India, and those never really joined up. So there wasn't sufficient oversight. So enter the law, and also because, of course, there is a number of economists present. So how do we then integrate culture in economic and legal terms? And we're dealing with this phenomenon of people being embedded in this environment which shapes their behavior. And I think this is a good image that visualizes this well. So there's something between people that makes them behave in certain ways and overrides their judgment. And we need to find a way of catching, of conceptualizing this problem. Now, I'm now sort of going back to the level above banking regulation. I'm talking generally about corporations and company law. Now, the way we conceptualize the firm is a nexus of contract, and that's a theory of the firm that was first articulated by Roald Coase. And the idea is that the firm is a marketplace through which individual actors interact with each other. So it is a little bit like a market where we establish hierarchies, and then there are the directors who are decision makers, and employees have long-term contracts. And it is sort of a way of looking at companies that individualizes the participants. So we say, here are the various groups and they contribute to the firm. And the firm then is, and this is important, an aggregation. So the mathematical operation is an addition, adding up. The firm is the sums of the contributions of their participants. So we're seeing a sort of an aggregation. It's like a heap of contributions taken together. And that theoretical concept is then developed into something called agency theory, which is associated with neoclassical economics. And just to say where I'm going with this, the hypothesis I'm advancing here is that the way we look at law, the way we conceptualize law, has blocks us from the possibility of seeing how corporate culture works. And I'm going to explain this now, what I mean by this. So neoclassical economics focuses on bilateral relationships. As I've said, the theory of the firm is one where we say the shareholders are the principals, the directors are the agents. The agents have the role of enhancing the return of the principals. So we're looking at two participants and how they have a conflict of interest between them. The firm then, as I've said, is another form of a marketplace. And it's about a conflict between two rational actors who each maximize their respective returns in monetary terms. Agents affect the well-being of their principals, so directors affect the well-being of the shareholders. Directors are the agents of the shareholders. And, very important, we have an assumption of rational actors. Now, this is a good idea, or rather agency theory has an important benefit because it helps to mathematicize problems. So it helps to make legal and real world problems suitable for an analysis through models. And there are a lot of benefits in this. So for example, it helps economics to engage with law. And there is a lot to be said in favor of interdisciplinary work. It also works the other way. It gives law an inroad into economic concepts. So at this stage, I'm all in favor, and this is a wonderful project. What I am now criticizing is that there has been a spillover into the legal discourse. So I'm not beating up economists. I'm actually putting the blame more in the court of the legal scholarship. And I'm saying that this sort of idea of conceptualizing the corporation and conceptualizing the law as a mechanism to help the directors do a better job in acting in the interests of the shareholders is problematic. So why is it problematic? Because it means, and now we can see why corporate culture is sort of an issue here, because we then only focus on the incentives of individual actors. So we're only looking at individual actors and their respective incentives. Performance-related pay is a normative recommendation. And also that framework was established in the greed is good climate of the 1980s. So what you now read frequently in law journal contributions is the directors have an obligation to maximize the return for their shareholders. I know of no legal system that has such a rule. The UK Companies Act has no such rule. There's no jurisdiction in the United States where it says anywhere that directors need to maximize return. This language and this idea of maximization comes from an analysis that was created against a certain background in another discipline and makes perfect sense there, but I don't think should have spilled over in this way into the legal discourse. So corporate law and regulation is now largely constructed against this background, and the approach works for where it comes from, but doesn't really work for the legal context in which it is used. So the approach lies on an unrealistic conception of human action. Law needs to work with a realistic conception of human action. And also, my topic here, it ignores corporate culture. So what is it then? How do you change that conceptualization? So I think we need to view organizations or firms as autonomous actors. And I'm going to now explain what I mean by this. So natural action has to be our assumption. So humans act sometimes rationally, but they don't do this very much, and they certainly don't do it always. And we need to be aware that humans act differently in different social contexts. And this is something that we all do. We behave differently in a professional capacity than we behave in a private capacity. We also adjust our behavior professionally, depending on the context. So I'm now speaking at an event, at an international event with participants from various jurisdictions. So I have adapted my content to that background. So I'm not telling you anything about very specifically detailed about English law. I also dress differently, I speak differently, being aware of my social context. Another way that social context informs my behavior is I teach for different universities in different countries. Every university that I work for has different processes, different policies. There are also different informal rules that I have learned in the context of interacting with people from those organizations, and they shape my behavior. So I'm a differently acting individual depending on my professional social context. When human beings work together, habits, routines, processes, procedures, tacit knowledge, and culture form. And that is something that happens to human beings when they work together, and we've all experienced this. So this is something, I don't know what's going on here. There we go. So this is sometimes referred to as social structure. Social structure being something that has occurred between human beings that creates laws in a form of habits, routines, procedures, so shaping behavior. And then there are phenomena you could call group loyalty and group think, which disengage individual judgments. They override our individual judgments. And this is measurable empirically. So experiments have been conducted, and I mentioned these in my recent book, where we can measure how the perception of individuals in an experimental setting that they're part of an organization causes them to act differently from how they act when they believe that they're not part of an organization. So you can measure this empirically. I think this is really important. So this is not something that that is sort of made up by anyone. It has empirically measurable consequences. And then we need to obviously say that there also exists human agency. So I think human agency is important. Agency theory is useful, but it is useful as a factor that shapes individual action. Human agency can ignore structure and it can modify it, but it is affected by it. And that modification takes time and effort. And I have seen my own employer, the LSE, go through a cultural change. When I first joined in 2001, students were largely irrelevant. In fact, they weren't even irrelevant. They were perceived of something, of being a little bit of a nuisance. They were here and we had to deal with them, but they weren't the focus of the organization. And this is very similar to how I experienced being a student back in the days when I was a student. There too, I had a clear sense that, yes, of course, I was there, and in some sense I was important, but actually I was a sort of a nuisance that they had to deal with. Now this has completely changed. We've turned ourselves around to an organization where students are now very important, where their well-being is taken very seriously. And that took a lot of time and effort and had to trickle through the organization. And that was a difficult thing to do, but I think we have achieved a lot in that space. So organizations are, I think, better conceived as autonomous actors, and that they are also more than the sum of the contributions of their participants. And this is because of those habits that write themselves forward and are learned by people and then passed on to people, and that they're sticky, so they're difficult to change. So there exists an autonomous structure, glue in the form of processes, procedures, and culture. And then as lawyers, we need to focus on this glue as well as on individual actions and agency. So the question then is one of how are we influencing corporate culture? And there I'm sort of now pointing to the work of the Financial Reporting Council, and they have recently updated their paper on corporate culture. They're talking about creating positive corporate cultures, opportunity and challenges. So this is a recent paper. And what they're identifying, and this is just a selection of their recommendations. So one is, it's really important that the board, so the leaders of the organization, act as role models, so that they do what the organization says is their culture and that has a stronger effect than well-drafted policies or mission statements. And then another thing that affects corporate culture is language and communications. So how does management talk to employees? How does the board talk to management? What kind of language is used? How are things communicated? So that has and then is culture on the agenda is another recommendation. So is this something that is identified as a sort of an agenda item that the board pays attention to, and are they thinking about what they should be doing in creating a positive culture of compliance? And then thinking about how performance is evaluated. So, and this is not just what does the manual say, but also how are decisions made in reality. HR decisions about things like leave or things like employees having health problems or mental health problems. So these decisions also affect the culture. And they send very strong signals about how people are expected to behave. A crucial role is played by middle management, who are amplifying or not a message that comes from the top. So middle management needs to be brought in and needs to buy in to a better cultural environment. And then induction and training. So this is the paper from the Financial Reporting Council. The Financial Reporting Council, to those of you who aren't familiar with this space, is a body in the United Kingdom. They write the corporate governance code. They oversee the audit and accounting professions, and they also write guidelines about audit and accounting. Okay, so then final slide, and that is the question of how does law and regulation now deal with this? And here are a few ideas. So the focus on identifying and punishing individual wrongdoers can be counterproductive. And I think the cases I mentioned at the beginning, where in the end who bit the bullet were fairly young individuals who then we could pin the blame to, in circumstances where actually what was wrong was how the organization was run as a whole. And then I'm referring to a paper here by Christopher Hodges. He has a paper on science-based regulation in financial services. And what he talks about is he uses the model that has been used in the context of safety of air travel. And of course, that's a hugely important topic. And they moved over some time ago now to a model where the individuals who made mistakes were not punished for those mistakes, provided they disclosed them. So the idea is that if you make the underlying idea is that most accidents that happen with airlines are accidents that happen because of human failure. So because of the imperfection of humans. Those mistakes are something that are a valuable source from which we can learn. So the idea was one of requiring people who make mistakes to share these with their superiors, and then for airlines to share this with the regulator. And once that's done, all's well, thank you for the information. And then the next step is working out what we can do in our processes to avoid that mistake from happening again. Fines are issued, but they are issued for failing to disclose mistakes. So you get into no trouble for saying, okay, I fell asleep at my shift, and that was because I had too much to drink last night. And if you pass that on, all's well. If you don't pass it on, you're in very big trouble. What they do about the information with you drinking at night, they may work out where should you stop over, how should we organize your shift. So there are sort of questions there. Another example is the failure to prevent model, which is now a UK example, and that can be found in the Bribery Act 2010, Section 7, and the Criminal Finance Act 2017, Sections 40 and 45. And this is now a model of criminalizing organizational behavior. And the way the model works is to say, if an organization, or if on behalf of an organization, a UK-based organization, bribes are being paid in another jurisdiction by anyone, so not just an employee, anyone who is paying bribes to facilitate the business of a UK company, the company is liable for the bribe, unless they can show that they had in place adequate procedures preventing the bribe, aimed at preventing the bribe. So these need to be adequate procedures. Plus, they also need to show that these procedures have been implemented and monitored. And when they can show that, they're free of liability. But the initial starting point is one of there is liability unless they prove that they had adequate processes preventing it. These may not have worked, but as long as they were adequate and were also were also used in their implementation, when they can show that, there is no liability. And that is better suited to going to the heart of the problem. So bribes are, of course, something that is a tempting thing to do if you want to advance the business of a company. And then of course you can punish the individual, but that doesn't get you very far, because the next day you'll find someone else who's going to be prepared to pay a bribe. And when really the problem is one of the organization not making it clear that they're not accepting bribes being paid on their behalf. Okay, and I think that's it. So what I've been doing, I've been talking about the problem of corporate culture. I've spoken about why I think that problem is currently not sufficiently captured in the legal discourse. And I have mentioned some examples here on how law can integrate culture into its analysis. And I think I'll leave it there. And I believe I've also now made up a little bit of time. And hang on, let me see if I can stop the share. There we go.
Thank you very much, Dr. Micheler. It has been a really enlightening presentation, trying to link up cultures and the legal, how actually it can be dealt with through a legal platform. Very, very interesting, at least to me, very personally also extremely interesting presentation and different thought process across. Having said that, I think there are quite a few Q&As and some questions from the participants also. So let me take the participant questions first. Yeah. Okay, that box is not opening up faster. So whatever has opened up faster, let me start with that. This question is from Dr. CKG Nair. A very enlightening presentation, Eva. Distilling the role of individual involved and the corporate culture may be difficult. However, there are examples where professional violations were for or also for personal benefits. How do you explain these? Oh,
yeah. So I would say the answer is there is individual agency, and there's free will, and there are people who are criminals. I'm not explaining it, or I have just explained it, but I'm also saying there are people who are not criminals, who in a toxic environment lose their moral compass, and then they do wrong in circumstances where they wouldn't have done so in a different environment. So I'm dealing with the second of those problems.
this is my own thought process. Basically, are you moving away from justice to justification when you're talking about corporate culture being a key driver of individual behavior? Is my first question. Second question or supporting question is, don't you think culture is a weak justification because it's just not that individual who was subjected to that culture? He had a peer group, and probably he alone was the wrongdoer. So don't you think that you're moving away from justice to justification while citing culture as an important driver of criminal behavior?
No. And the reason I'm not doing that is I have no time for fraudsters, even for people who commit fraud in that cultural environment. So I think they are to blame. They deserve their convictions. I would not convict them. But what I'm saying is that in addition, there is something called organizational fault. So I am conceiving the organization as an actor capable of its own fault. And the trigger of that fault is this toxic culture that arises when people act together. So I'm justifying, what I'm saying is, in these examples, what the legal system should have done, in addition to attaching criminal liability to individual traders, they should have attached liability also to the organization. So no excuses for Hayes and Abaduli.
Okay. Okay. So the wrongdoer is definitely going to be punished, but can we do something about the culture that induces it? Maybe there will be lesser wrongdoers. That's your argument,
Yes.
as I understand. Yeah. So one question from Dr. Shanmugam. Thanks, Eva, for introducing the problem of corporate culture. Connecting this to markets, can participants read the culture turning toxic through financial reports? Or do you suggest that there shall be a separate set of disclosures that may help market men to identify the evolution of an unsustainable culture? Or shall there be a regulatory mandate for rating of corporate culture? Or is there any is there any other solution, reading all the financial reports and news about corporate, that shall come up to highlight corporate culture to the market participants? So I think he's suggesting about some alternative to the disclosures which are getting made. Such a solution will help greatly in market surveillance, especially for exchanges with listed entities. So, not sure.
Yeah, so I think I'd like to answer that question in two stages. So the first question is one of, how would the regulator perceive toxic culture? And I do think there are things like pay awards, and how does promotion work, and they will have to, what's the tone between the members of staff? Is there a lot of shouting happening? Are people do they feel empowered to blow the whistle if something goes wrong? Is there a whistleblowing policy? Has anyone actually ever blown a whistle? Are there complaints? Have they been recorded? And if there are no complaints, I think that's a warning sign, because everyone's happy here is never the case. So if you have no complaining people, you're not taking complaints seriously. So regulators know this. Like, it's not something that, like, regulators, I'm sure, have very good antennae for spotting a culture where nobody tries to speak up. And there's sort of that. So that's the one thing. Now, the other section of that question is, can disclosure help? And that's directed towards, how can investors know about whether the culture and the company they invest in is toxic. And I haven't given this much thought, so I'm now reacting here on the hoof. But I would say that, like regulators, culture can be perceived between the lines. So you are able to, like, I would need to think more about, what is it that you want disclosure on for, to measure culture. So maybe now thinking about it on the hoof, these are things like disclose how you're paying people, how you're promoting people. What are the performance targets? What happens when people don't perform to target? There's in the context of the research for this book, I read an article from the 1980s where a car dealership every month fired the worst performing salesperson. So every month, the person that sold the fewest cars was fired. Now you can immediately see the knock-on effect of this is going to be mis-selling of vehicles. That's the only way this is going to work. So disclosing how staff are treated, how staff are reviewed, what happens to staff when they don't perform, and how are complaints dealt with. So I think these are the factors. And then if you ask me the question, would it help investors to know about this? That I think goes to the question of how much does disclosure actually help? Does the market pay attention to the information disclosed? And that's a much bigger topic. But I do think that the exercise of having to disclose affects the person who has to say what they're doing. So I think there's a sort of some effect in that. But I think I'll leave it there.
Yeah. We have a question by Dr. Kevin James. Failure to prevent model can be captured by principal agent model. So firms want to maximize profits and pay bribes and set up low-level employees to take the legal risk. That's optimal for senior management. So to stop the problem, the regulator or law has to go after the people who are actually responsible and change their incentives, get them through a failure to disclose. So what are your comments here?
Yeah, so my comments, so of course you can always say it's all the directors. And they are ultimately the decision makers. So if they do this, then that happens. And my point is, it's not that easy. So my point is, that's exactly the weakness of the agency model, that you have an individual decision maker who becomes enlightened, and presto, LSE starts caring about students. For LSE to move from an environment when I was a student where I was perceived to be a nuisance to the teachers of the organization now caring about my well-being, that probably took 10 years. And that's because you need to feed this change in how people view the world through the levels of an organization. And just telling the board to do something, or just the board saying, I now think students are important, and the director of LSE making some nice speeches about how much he cares, isn't enough. And what I'm putting to you is that the board and the executives have very limited power. And it takes a lot more to change organizational behavior. So that's how I would respond.
Yeah, so I think we've already walked into the break time. Yeah, and of course, there are a few more questions and comments on the question box, which we will route it to your mail ID, Dr. Eva. A wonderful presentation, a different thought process. I think it has impressed all of us. So thank you very much. I would like to thank both the speakers of the session, and thank you, LSE, for the collaboration. So, and thank you, NISM's management, for making it all happen. And thank you, wonderful participants. You've been raising so many questions that we have just run out of time. Thank you.
Thank you.